Okay, everyone, let's get started. So, for our final topic of the year, we are going to look at terms. And essentially what we're looking at in these 2 weeks are what is the contract in terms of what are the parameters of the contract, which promises or warranties or obligations were included in the contract and which were not. And so to answer that question, we're going to look at when are terms, express terms, i.e. terms that you can have been expressed to the other party, either orally or written. When are those terms part of the agreement, or are they merely perhaps representations that are non-contractual, which might give rise to a claim and misrepresentation, but not one for breach of contract? So when are express terms part of the contract? And then on Wednesday, we will start looking at the question of when are terms that are not express, i.e. no party has said them or written them expressly, but when are terms implied into the contract because they're necessary for the contract to work, or for business efficacy, or because it goes without saying. So these two subtopics, incorporation of express terms and implication of terms, are both trying to answer the same question. What is the contract itself? What are the parameters of it? Which promises are part of the contract and which are not? As I say, today is about those promises or terms that are written or expressed orally, and then on Wednesday we'll start looking at terms that are implied. Okay, so once we know what terms make up the contract and which terms do not, and are therefore not terms, we have to figure out how we interpret those. And what we'll do in our last subtopic on interpretation is introduce you to the debate, because really interpretation of contractual terms comes down to two fundamental camps of interpretation that are in disagreement with each other. And as we will see, the interpretation debate has swings and roundabouts based on fashion and on, I suppose, which side is dominating. And I tend to think it's an irreducible debate. I don't think there is a right answer often to interpretation, or the approach to interpretation, but we will give you some idea of that debate at the end there. So that's the plan for the next 2 weeks as we lead up to the exam. A reminder that your exam is less than a month away, the 11th of November. So please do be aware of that. Start making your notes if you have not already done so. Start catching up if you are not caught up with the lectures, and start practicing those previous exams that are available on the database. I will also release some further practice questions on Canvas this week, okay, from previous exams. Now, has anyone got any questions about the end of last week, the mistake topic that we finished on Wednesday? All good? All happy? Okay, great. Well, if that's the case, let's get into it. When are terms incorporated into a contract? The first case we're going to look at is Couchman and Hill. And this case, this case is an example of the courts going beyond the written contractual document to add to the terms of the agreement with oral terms that were agreed outside of that written document. And this case is an example of a way in which the rule that used to govern contracts, what's in contracts and how to interpret them, what you might have come across, the rule known as the parole evidence rule. This case is a great example of how the parole evidence rule just ceased to have any practical effect. So the parole evidence rule derived, and it was very important prior to the 20th century, the idea that contracts are written documents, and that when the contract is a written document, then that written document is the evidence of the contract. And for purposes of certainty, both for other parties but also for the parties themselves, one is not to go outside what's sometimes described as the four corners of the contractual document to amend, vary, or contradict what's within that contractual document. So you couldn't, thanks to the parole evidence rule, lead evidence to suggest or to bring evidence from outside the contract to try and interpret that document. But also you couldn't lead evidence from outside the contract itself to suggest this contract isn't the entirety of our agreement, that there are other terms outside the four corners of this document. Because that would be going against the parole evidence rule. That would be varying, amending, deleting a term in the written document. The benefits of the parole evidence rule are obvious. You have the contractual document, and that is the only piece of evidence you need to lead in court. So there is no protracted debate about what the contract is, or indeed what the contract means. Which means court cases are short, they're sharp, they're to the point, and you have a greater chance of knowing which way they'll go just by reading the contract itself. So obvious efficiency and certainty benefits. The problem with the parole evidence rule is that quite often the agreement is not wholly contained within the written document as a matter of fact. That the parties are not versed on the law, so they don't realise that the writing is key, or they are versed in the law and they just, like all humans do, muddle through situations where they're trying to get a deal done or they're busy people. The point is that there will be often cases where the agreement and enforcing the agreement is not... the agreement as written in a document is not actually enforcing what the parties agreed to. And so over the 20th century, you had holes being, smashed through the parole evidence rule, such that by the end, people would give it lip service, but it wouldn't have any practical effect. And one of the ways in which the parole evidence rule was weakened was by these sorts of cases of Couchman and Hill, and the other example we have J. Evans. So let's have a look at this. Couchman and Hill. It's a case that takes me back to my Danny Burke roots, where you get a purchase of a heifer at an auction. The heifer is obviously a valuable piece of property, livestock, and the purchaser was very keen to ensure that the heifer was unserved. That is, the heifer wasn't pregnant at the time that she was being bought. Why? Because there's a risk in when calving that the heifer will die. There's also the fact that maybe that the bull was not the bull that the purchaser wanted to be serving this heifer. So it was very important that this heifer was quote unquote unserved, not pregnant, not had the bull put to her. This was described in the sales catalogue as unserved. The purchaser, though, said, look, if I'm going to bid on this heifer, I want you to personally reiterate and guarantee to me that this heifer is unserved. So he asked the vendor and the auctioneer, both of whom personally confirmed that the heifer was unserved. And on that basis, the purchaser bought the heifer at auction. It turned out that both the vendor and the auctioneer were wrong, that the heifer was pregnant, and the risk that the purchaser was worried about eventuated. He bought the heifer, she was pregnant, and she died when calving. Purchaser is obviously upset. He's bought a heifer, very valuable, and she has died, and she died for the very reason that he was concerned about and had asked to be confirmed would not occur. So he sued for damages for breach of contract, particularly for breach of a warranty as to the quality of the heifer, that she was unserved. So he'd contracted to buy this particular cow, they'd given it to him for the price, so it couldn't be breach of contract for failing to deliver the cow, but it was that the cow did not have the quality warranted. At trial, the purchaser failed. And the reason the purchaser failed was that the conditions of sale of the auction, which were written and notified around the auction site, included an exclusion of liability clause. The clause saying, effectively, that the lots are sold with all the faults, imperfections and errors of description. All lots must be taken subject to all faults or errors of description, if any, and no compensation will be paid for the same. This is a clause effectively saying, buyer beware. And if you buy something that doesn't live up to the quality that you expected, too bad, the vendor or the auctioneer is not liable. And the trial judge says, well, I'm sorry, when you entered into this auction, you were agreeing to the printed terms of that auction, which were available not only in the sale catalogue that you had access to, but also on the signs that were also around the auction site, which you also could read, very clearly excludes liability for any defect in quality. And so therefore the purchaser failed. But he appealed, and he appealed on the strength of these personal guarantees that had been given him by the auctioneer and by the vendor that this particular heifer was not pregnant. So the question was this oral guarantee or oral promise incorporated in to the sale agreement? And again, the parole evidence rule would simply say, no, the contract is in the written terms and we can't amend or vary them by anything else external to those written terms, any evidence. But Couchman and Hill says otherwise. It starts off with those written terms and says, look, these are clear. And when you do the enter into the sale, you are clearly signing up to them. But, the court says, they were always free to be varied by the purchaser and the vendor beforehand. They were the default rules, if you like, for the sale, and the purchaser and the vendor could amend or vary those by agreement. Now, so the question is, what did they do? Did they actually do that? And to answer that, you need to answer, well, what did the parties intend through their oral question and answer? By saying, can you confirm that the heifers are unserved? And being answered, yes. The defendant said, well, look, what we intended was that I, as a man of honour, was making an honourable undertaking that, as far as I'm aware, these heifers were unserved, but at the end of the day, that didn't change the risk that the purchasers were buying this heifer with all the defects in quality that she had. It didn't change the contractual risk placed upon the purchaser in the conditions of sale and on the auctioneers, in the conditions of sale. Effectively, that the question and answer entered into by the purchaser prior to buying the heifer had no contractual effect. The plaintiff's view was obviously that it did have contractual effect, that the purchaser was only willing to enter into this agreement to buy this cow if, as a condition, the vendor took the risk that she turned out to have been served. That is, that it was a contractual undertaking by the defendant which changed the risk contained within the conditions of sale. And the Court of Appeal held that that view was correct. The court held that the express written terms were, in this instance, overridden or limited by the oral undertaking, by the question and answer that the purchaser and vendor had gone through. And whether or not that oral question and answer overturns the written document or the written agreement is very fact specific. And what's the fact that you're looking at? What was the intention of the parties when they had that conversation? Was it to enter into an oral, essentially, warranty as to quality? And the court said yes. Sometimes a question might be ambiguous, or it might not be clear what the legal effect of such a question is, and in which case it wouldn't change the written contractual terms. But in this case, it was very clearly that I, as the purchaser, am not going to buy this cow unless I have an assurance, not just an honourable assurance, but a legally binding assurance that that she has the qualities of being unserved that I would prefer. And so here's a clear example of written terms being varied or in fact displaced by an oral agreement. And if we're allowing this sort of evidence, then very clearly the parole evidence rule is not so strong as it once was, because you're very clearly going beyond the written terms and allowing in evidence and then disputes about the evidence about oral conversations, which are obviously far less easy to prove than the written sale conditions, which everyone has a copy of. So the key reason, or one of the key reasons for the parole evidence rule is completely undermined by allowing such oral undertakings in. But in the court's view, that's because we're here to enforce the agreement howsoever it was entered into. And if that agreement is partly oral and partly written, as it was in this case, then that's fine. We'll enforce both. And so to the extent that we need to vary the written terms to take into account the oral terms, then that's fine by us. But you need to look carefully at the facts. And I'll finish off by quoting a little bit from Lord Justice Scott. I think conclusively from the plaintiff's evidence, taken in conjunction with the admissions of both defendants, that the words, if used, which they denied, would have bound them. It was obvious that it was the stipulations that prompted the question. The plaintiff was not a lawyer, but he knew what he wanted, and he got it. So did the vendor, and he gave it. What the plaintiff wanted to know was where he stood before he made an offer which the fall of the hammer would turn into a contract. Clearly wanted some legal protection and would only buy if he had such protection. So, an oral question and answer incorporated into the contract that was otherwise wholly written. Does that make sense to everyone? Are we happy with that so far? Any questions at all? Okay. You're obviously going to have issues with proving the oral warranty. Obviously much more difficult to prove than the written terms of contract. And then even if you can prove that, as the purchaser in this case was able to, you then need to prove that the intention of the parties was to make that undertaking part of the contract, to have legal effect if that undertaking is not complied with. But if you can show that, the fact that it is an oral undertaking in an otherwise written contract will not prevent you from arguing that an oral undertaking is indeed part of the contract. Okay? Okay, all happy? Good? No? Okay. The next case is a very similar one in outcome. It's another example of a written contract, and indeed a written exclusion of liability, being amended or varied by a oral undertaking. Again, pre-contractual oral undertaking. So what happened in this case? Well, it's a shipping case where you have the importer of goods, factory manufacturing goods, machinery, who bought the machinery from Milan and shipped it up to England. And you get it by train from Milan all the way up to Rotterdam, I think, or Amsterdam, can't remember, one of the two. But then you've got to get across the North Sea, so you've got to use a boat. This is Channel Tunnel. So you've got to get the goods across by boat. The importing company had always used, whenever they'd shipped in goods, had never used shipping containers before. So shipping containers came about, I'm not sure when, 50s or 60s. This particular importer had never used them before and was a little bit concerned about using shipping containers. And so when the importer found out that the goods were to be used, were to be placed in a shipping container, the importer said, okay, that's fine, but I do not want the goods stored on deck, because I'm worried that if they're stored on deck, they will get sea air into them and they'll get a bit rusty. I want them in the hold under hatches. Unfortunately, for whatever reason, there was a mistake and the goods were placed on deck in a shipping container. The good news is they didn't get rusty from sea air. The bad news was that they were lost overboard. And so the importer said, well, the importer was insured, so it took the insurance money and ran away, but the insurance company is taking an action against the shipping company to try and recoup the money that it had to pay to the importer. So the argument is, you promised to put the goods above deck if you used a shipping container. You failed to do so. That was a breach of your contract, and due to that breach, the goods were lost. If they'd been below deck, they would not have been lost in the seas, in the heavy seas. Now, the first obvious person to sue is the ship owner, but you can't sue them because they'd excluded any liability for goods lost in the bill of lading. The bill of lading being the contractual document that you sets out what goods you're taking on board ship and where you're going to and whose liability for losing them, etc. And it clearly said that the ship owners were not liable. So, instead, we're suing the forwarding agents, though the company that arranged the transport of the goods from Milan up to the Netherlands and then onto the ship. And the basis for this was this conversation that the importers had had with the forwarding agents, whereby the forwarding agents agreed orally that the goods would not be carried on deck. The problem was this was never put into writing. So you've got an issue about having to prove it for a start. But even if you can prove that that conversation took place, you then run up against the printed terms and conditions, which stated that any goods shipped would be shipped at the shipper's risk, that is, by the person owning the goods who's shipping them. So they're your risk when they go on board the boat. So the forwarding agent said, look, I'm sorry, but this was at your risk, and you knew it. And the insurance company, on behalf of the importer, was seeking to rely on the oral term to displace this exclusion of liability. And just like Couchman and Hill, the court said that this agreement was partly oral and partly written. That the agreement was not contained wholly within the written document, but also within the oral terms that the parties had agreed to first. And that you have to read both the written terms and the oral terms together. If the forwarding agent is correct and the written exclusion of liability clause prevails, then the practical effect of that is to make the oral agreement that the goods won't be shipped on board deck meaningless, or at least merely a wish that, oh yes, we promised to do this, but if we don't, we've got no legal liability. Well, that's not a contractual promise at all. It has no legal effect. Instead, the court said that the parties must have intended through this conversation that the oral agreement to put the goods below deck, not to ship them on board deck, be operative and have legal effect. The conversation itself was said that, I'm going to use this the shipping the forwarding agent said, I'm going to use these shipping containers, and the owner of the goods, the importer, said, look, I've heard about these containers. I'm afraid that our machines may get rusty if they're carried on deck. They must be not carried on deck. And he was assured, if we do use containers, they will not be carried on deck. So the question is, what does that actually mean? Well, the court said that was a contractual promise. He wanted assurance, a legal assurance, that if they were carried on deck, he would be protected from damage. And so therefore that oral clause has to be mean something. And the court said that the oral term or the promise given by the forwarding agents was intended to be part of this agreement, and it had an effect despite the exclusion clause. It's exactly the same as the result in Couchman. One thing they said was, look, this is not two separate agreements that must be read together. So it's not a new collateral agreement, one of which is written, one which is oral. That was always the fiction that you could use to get around the parole evidence rule, is you could say, we're not amending the written agreement, we're just enforcing this wholly oral agreement, which is collateral. They should be read side by side. The court says, no. We don't need to worry about that. Instead, we're just giving effect to this one agreement, which was partly oral and partly written, and this oral promise was a new term which was to be included in their shipping arrangements. Again, if the written term was to apply without being amended or limited in its scope, then the oral term would be illusory. That is, the oral term would have no effect, would have no impact. And to hold otherwise, according to Master of the Rolls Lord Denning, would be to destroy the business efficacy of the new agreement from the day it started. The promise to only use shipping containers below deck would have no business efficacy unless we give effect to this oral term. So the court's looking at what is your actual business agreement, not just what the written terms are, but any evidence of an oral term can be led and can be accepted, and if it is led and accepted by the court, then it will be read side by side with the written terms. And remember, this doesn't completely do away with the written term. The written term was an exclusion of liability which placed the risk of the goods being lost or damaged at the shipper's risk. So in all other instances, if the goods had been placed below deck and still been damaged, the exclusion of liability clause would have applied, and the importer would not have been able to claim the loss of those goods or the damage for those goods. But it was only when they said, if we put it in a container, we'll put it below deck, were they taking on board obligations which displaced those written exclusion clause, that written exclusion clause. Okay, so that was the way you could read both terms together and to give effect to both terms. The shipper, the risk is on the shipper, except if they're put in containers and not stored below deck, which is what happened here. But once again, clearly the parole evidence rule is not being enforced in the way it once was. Everyone happy? Make sense? Good. Okay. Easy. The next case is even easier because it's what we all know to be true, or at least without any evidence, without any legal experience. Hopefully, you know what this case stands for, even if you've never heard of the case itself. When you sign a document, that turns out to be a contract, What's the effect of your signature? What does it mean to sign it?
You're agreeing to it.
Fantastic, you're agreeing to it. Ah, but I never read it. Still bind me?
But then why did you sign it?
Great, yeah. Why did you sign it? When you sign a document, a contractual document, you are saying to the world, I agree to these terms. And therefore, you are bound to those terms, and it is no defense to say, but I didn't read it, or I didn't understand it. So if you click the I agree button, similar sort of thing. You are saying you agree to those terms irrespective of whether you've read them or not. And that's effectively what the case of Lestrange and Gracob stands for. That signing a contractual document is evidence that you've given to the whole world that you agree to it and that you are bound to those terms. So the dispute here was about a cigarette vending machine, which had been purchased on a number of payment. It was a payment plan where you didn't pay everything up front; you paid over a certain period, and the purchaser refused to pay anything more because she argued that the cigarette machine was defective. So she refused to pay any owing on the purchase price and instead sued for damages for failing to provide a working cigarette machine. The purchase was made under a written agreement that the purchaser had signed, and one of the small but legible fine print terms was that it excluded any warranty as to the machine's condition. Which means, again, it was buyer beware. The purchaser was buying this vending machine at their own risk. And if it turns out to be defective, too bad. And she argued, I never saw that term. I didn't know that that term was there. I would never have agreed to that term. So what was the effect, though, of her signature on the document, the contract? Did that incorporate all the terms contained within it? Do you need to show that she knew what she was agreeing to and that she understood what she was agreeing to? And the court said, no, you didn't need to show that at all. You just need to show that she signed the document. So it's different to these ticket cases we're going to look at next, where there is no signature on the written terms. But instead, here there is clearly a signature. So you do not need to show that the signatory knew of or understood the terms. You are, by your signature, saying to the world, I know what I'm signing and I agree to it. Or at the very least, I don't know what I'm signing, I don't understand it, but I'm signing it anyway, so I'm prepared to be bound by whatever's on this contract. So when you sign a document that is rebuttable, but there's the presumption that you have agreed to these terms and you are therefore bound to them. But it is a rebuttable presumption. So what, according to the case itself, what did the court say? What facts or circumstances could rebut this presumption that you're bound to what you sign? How could Mrs. Gracob, I think, I forget which one's which. How could the purchaser have escaped this written term that she'd signed? How could she escape the effect of it? What could she have said? Yeah, I signed it, but what? Yeah.
There was an oral agreement that showed otherwise.
Okay, yes. Yep, so there's an oral agreement yep, so like a J. Evans or Couchman and Hill. Yep, okay. Yes. Yep. Maybe. Okay, that's one scenario, yeah.
If there'd been misrepresentation, she could have.
Great. If there was a misrepresentation to her, what would that misrepresentation be, do you think? Or what's a good misrepresentation that would have got her?
If someone had purported to explain the agreement to her, but had said that there would be a warranty, or that they were taking responsibility to some extent for the condition of the machine.
Great, yeah. So a misrepresentation as to the effect of the document, the contract. Very similar to non est factum. That you have signed something because you've been misled in some way as to the effect of the document itself. Or indeed, if they've been fraudulent in some way. But also, you might get out of the effect of your signature if you can show that you were not signing, or you didn't realize you were signing a contractual document. That you thought that the document was for some other purpose. Usually because it's been misled to you what the purpose of that is. There's a very famous case, the name escapes me, but it's the wedding dress case where a new bride took her wedding dress to the dry cleaners to be cleaned. And she handed it over, and she was given a docket with the amount that was owing and when she could pick it up and what item she had delivered. And she was very smart. And she said, why? And then they asked her to sign the docket. And she was very smart. And she said, why do you want me to sign it? And they said, it's just a receipt so that we all know that this is your wedding dress and when you can pick it up and how much it will cost. So she signed it. Went away, came back and picked it up, and they'd completely ruined the dress through the chemical dry cleaning process. And she sought to sue for the value of the dress, and they sought to rely on the printed terms and conditions on the back of the receipt, which excluded liability for damage done to dresses, or I think there was a limitation clause maybe. And the court, and then they said, well, you signed it, and so you're bound to these terms and conditions. And the court said, no, she was misled as to what she was signing. She thought she wasn't signing a contract. She was merely signing to show that she assented to the, that she agreed that this is what she'd given them. It was a receipt. And so in that case, the court said the written terms and conditions on the back didn't bind her, even though she'd signed them, because she didn't realise there were written terms and conditions, and she'd been misled as to the effect of her signature on this particular document. So you have to show that you're signing a contractual document, that you're aware that it's a contractual document, and that you are, by your signature, saying, I agree and have read and understood and agree to these terms, whether or not you actually have. But if you can show that, then you're bound, as I say, subject to those exceptions about fraud or misrepresentation. And it doesn't matter if you've read the document or not, you're still bound as if you had read it. The only question, as I say, is have you been misled? And perhaps why did you think you were signing? Are you actually signing a contract, or did it appear that you were signing something different, like a receipt? But otherwise, she was bound to that exclusion clause. Hopefully, none of that's a surprise to anyone. Don't sign anything unless you know what you're signing. Certainly never say, click, I agree, unless you've read the entire thing.
I just have questions. So, for example, if the receipt says that that
Yeah.
asks you to refer to the fact, is there argument available that the person in the receipt that say that was the contract?
So sorry, if the receipt says see the back for printed terms and conditions, and but if they say to you, oh, it's just a receipt, I think they're going to struggle to rely on the fact that it says printed terms and conditions. Oh, if they didn't say that, they just said sign it. Yeah, no, that is right. That would be different, and that would be the smart thing for the person in the dry cleaner to say, nothing, or look at it yourself. As long as it's clear, or it should be clear that this was a contractual document, it had terms and conditions, then yeah, you'll be bound. Yeah, good question. Other questions? By the way, there is case law that says, not in New Zealand but overseas, that those click wrap contracts, it's exactly the same as signature. Yeah.
Do the dry cleaners have an obligation to talk you through the terms or to state that it is a contractual document, or does that burden fall on her?
So they don't have an obligation, but if she asks her why am I signing this? Why do you want to sign this? They have an obligation not to lie, right?
Yes.
Or not to say something wrong. So they could say nothing, like figure it out for yourself, or they tell the truth. If they tell the truth, then obviously she's bound if she signs it. If they say nothing, or say you look at it yourself, then I think the courts would say, okay, well, what does this look like? Should she have realised that this was a contract, or that there were written terms on it? So that would be it. But yes, they certainly can't lie, but otherwise, yeah, they can stay silent. And then the obligation, I think, would be on her to figure out what she's signing. And generally, when you sign something, you know that that has some import, right? So you should be careful about what you're signing.
This is like objective test or something. So does the person actually just need to know that there are the fine prints there, or?
No, so she didn't realise there were fine print here, or she didn't read it. Wasn't aware of it. So no, if you sign something and it's clearly a contract, you should have known it's a contract, you're bound to all the terms whether you read them or not. If you sign something, but the question is it clear, or should it have been clear that it was a contract, I suppose is the question. That's the question. So objectively, you can't escape the effect of your signature by saying, I am particularly unobservant and dim. Yeah, I think that's, yeah. So objective. So don't sign anything is the answer. Don't sign anything. Just like the one thing to take away from equity is never be a trustee. And company law, never be a director. Cool. Any other questions at all about that? Does it make sense? Cool? Okay. So written document, you sign it, you're bound. What happens though if, we've got a couple more minutes. What happens though if you have a written document which you don't sign? Are you bound to those terms? And we look to the answer for that to the ticket cases, which were referenced in Lestrange and Gracop. Why? Because they're all based on tickets, funnily enough. Often at railways. And usually about the ability to sue railways for losing your luggage. So Parker and South Eastern Railways is one of the most well-known of these cases. The facts where the plaintiff left his bag with the railway company in the left luggage counter. He paid his 2 pence and was given a ticket, and on that ticket it had a number which corresponded to the number that his bag was left under, I presume the locker, and the date with at which he left his bag. It also contained words at the bottom, see back. And on the back side of the ticket was a term, well, there was a number of terms, one of which limited the railway company's liability for lost goods. Effectively, if we lose your bags, we will pay you no more than £10. irrespective of how valuable the goods actually were. It's a very smart thing to have in a bailment contract like this. The plaintiff was given this ticket and his evidence was he just pocketed it, didn't look at it properly. It was held that he came back for his bag, the bag was lost, it turned out the railway company was negligent in losing his bag. And so he sued them for the value of his baggage. I don't know what was in the baggage, but it was more than £10 worth. And the railway company sought to rely on this limitation of liability clause and said, yeah, we're negligent, sorry, here's £10, but we're not going to pay you any more than that. Why? Because there was a term in our contract. What contract? I didn't sign anything. No, but there was a term on the ticket that you were given at the time you left your bag with the railway company. So the question is that a term of the contract? He hasn't signed it, but he's taken the ticket with the term on it, and he hasn't complained. So by his actions, you could say he has agreed to these terms. If he didn't agree, he should have kicked up a fuss at the time. But he didn't kick up a fuss, he walked away, so he's agreed. So it's just like if he'd signed it, he's bound to these terms. And after the break, we will figure out if that is correct or not. So we'll come back at 5 past, everyone, and we'll look at the rest of Parker and Southeastern. Hi. Of course.
Is the mic off?
Okay, let's get going. Okay. So the problem in this case is that the ticketing company... Thanks, everyone. The ticketing company, or the train company, is trying to rely on this contractual term that wasn't signed by the plaintiff. So they're going to have to rely on some other way of demonstrating that the plaintiff agreed to these terms, right? You can't impose terms on the other party without those terms being agreed to by the other party. So we don't have a signature, so we can't rely on a signature to show assent and agreement. You're going to have to rely on something else to show assent and agreement, some other conduct. And that's what Parker and South Eastern Railways is trying to figure out, is what conduct is necessary to show assent. So Lord Justice Mellish starts off by saying, look, generally we approve assent by signature, as we've just found out. Otherwise, we need to go and prove assent through some other means. But if we can show that you have assented to these terms through some other form of evidence, then it doesn't matter whether or not you've read those terms. Just like if you sign a document, it doesn't matter whether you've read it, you're bound. Similarly, if you haven't read these terms, but by some other means you've shown that you agree to them, it doesn't matter whether you've read them or not, they still bind you. So as Lordship says, look, if you receive a document and you know that that document contains contractual terms and you don't object, then you are bound to those terms. The fact that you don't object and continue on with the contract says to the other party you've agreed to their terms. The problem was here they knew that there was writing on the ticket, but they didn't read that writing and therefore didn't know it contained contractual terms. And the mere fact that they knew there was writing on it wasn't enough to show that they were bound by those terms. Because, of course, the most obvious thing you would think when you get a ticket with writing on it is you would expect it to be a receipt for your goods, so that you can come and present it again and they can give you your goods back, like a ticket for a cloak. So the question is, according to His Lordship, what would a reasonable person in the plaintiff's position think that this ticket contained? Would he think that it contained contractual terms or not? And to answer that, you can look to the presumption prevailing, according to the court, in the common business practice that you're engaged in. So, turnpikes, for example, when you're going through a toll road, you'd be getting a receipt. Generally, you would not expect that to have contractual terms. So, any contractual terms on a turnpike receipt would not bind you. However, bills of lading, that is the document you get when you put goods on board a ship, always contain contractual terms. Everyone should know that. It's the common business practice, and so therefore you're bound by a bill of lading terms whether or not you've signed it and whether or not you've read it, and whether or not you know bills of lading have terms or not. Your ignorance as to what a bill of lading is doesn't prevent the other party from relying on the terms when it is common business practice to include such terms in a bill of lading. And so the question is looked at objectively. Your subjective ignorance will not save you from being bound to terms when objectively you should have known that there were terms on this document and you therefore should have kicked up a fuss if you didn't like those terms. So the question is, has the railway company in this case done enough to give reasonably sufficient notice that there are terms on the ticket? That's the question that must be asked. And there are 3 questions to be put to the jury in cases like this. And His Lordship says we need to have a new trial with these 3 questions being put. The proper direction to leave to the jury in these cases is, page 423 of the judgment, if the person receiving the ticket did not see or know that there was any writing on the ticket, he is not bound by the conditions. If he knew there was writing and knew or believed that the writing contained conditions, then he is bound by those conditions. But if he knew there was writing on the ticket but did not know or believe that the writing contained conditions, nevertheless he would be bound if the delivering of the ticket to him in such a manner that he could see there was writing upon it was, in the opinion of the jury, reasonable notice that the writing contained conditions. Has the ticket company, the railway company, done enough to bring it to your attention that this ticket has conditions upon it which will bind you if you enter into this contract? And that's an objective question. Lord Justice Begali reaches the same conclusion and says there should be a retrial in this case. And he discusses the general practice around the issuing of cloakroom tickets, which is analogous. What, again, the common business practice, what do people generally think the ticket is for? Or, alternatively, if the common business practice is for these tickets not to have written terms and conditions, they can still show, the companies can still lead evidence to show that they gave notice to this particular customer that this particular ticket had terms on it. I.e., here's your ticket, please be aware there are written terms and conditions on the back of it. Clearly that would bind the plaintiff. Or if he had actually read it and saw that there were terms on it, then they would be bound. Or if there was previous experience, if he had gone to this ticket booth many times before and knew that the practice of this ticket booth was to give out receipts with terms and conditions on the back, then that would also bind the purchaser. So, you look objectively, generally, what are these tickets thought to contain? If they're generally thought to contain terms, then it binds the purchaser. If they don't generally contain terms, then they don't bind the plaintiff, unless you can show that the plaintiff had some other knowledge, aside from common business practice, that these tickets had terms on them. And that knowledge might come from being actually told, or from previous experience, or from looking at the ticket himself. Lord Justice Bramwell is the 3rd judge, and he's dissenting only insofar as he doesn't think it needs to go to a new trial. He thinks clearly the ticket company is correct, that he is bound. He says, look, if the plaintiff knew that the ticket contained terms and didn't object, he's bound. Here he holds that the plaintiff was indifferent. He knew that the ticket related to him in some way and didn't read it. So he thinks there's no difference in this case from if he'd been told to read the ticket by the clerk at the ticket booth. He thinks practically the railway company had done all they could to bring it to his attention. They knew that it related the plaintiff knew it related to him and should have read it. And if they failed to do so, it is their fault. So effectively he's saying that objectively the railway company did bring it to his attention, or did everything that was reasonably practicable to bring it to his attention. He should have read it. He didn't read it. It's his fault. The other 2 judges don't go so far on the facts. They're prepared to leave the facts to be found by the jury, so they order a retrial. But they all agree that the question is whether a reasonable person would think that this ticket has terms and conditions on it. And if a reasonable person would think that they have terms and conditions on it, then the person taking those terms and conditions would be bound. The idea being that you get your ticket You should read it if you know there's terms and conditions on it, and you should complain about those terms and conditions if you don't like them. But if you don't complain, you've agreed. Make sense? There's an interesting, funny little aside in one of the judgments. I think it's Bramwell. Yes, where he says part of the reason why the jury found for the plaintiff in this case, and not the ticketing not the railway company, was that the defendants are a railway company, and that we all think that they're caput lupinum, which means wolf's heads, which were criminals that you could kill without trial because they were so beyond the pale. So he's just making a comment there that probably the sympathy of the jury was with the person taking the ticket rather than with the railway company, but he's just saying, let's just imagine they're not railway company. Let's think about this a little bit with a little bit less emotion. Anyway, now you know what a caput lupinum is and why railway companies are caput lupinums. Cool. Okay. Let's have a look at a case where similar situation, but the ticket was held not to bind the plaintiff. Chapelton and Barry, a case where set in the summer of 1939, which by all accounts was an excellent summer weather-wise. The facts of this case were that the plaintiff went to the beach, Mr. Chapelton went to the beach with his companion and hired a deck chair from the defendants to sit on the beach, just like in the picture. There were a pile of chairs beside a sign which said, hire of chairs 2 pence per session of 3 hours. And the sign also respectfully requested the public to obtain tickets from the attendant and to keep them. The plaintiff got 2 chairs and got 2 tickets from the attendant and placed the tickets in his pocket. And he had no idea that the tickets contained conditions that were printed on them. He went to sit down on the chair and fell right through it because it was broken. And he badly injured himself on the sand. And so he sued the council for negligence in failing to keep these chairs in workable order in such a way that it was reasonably foreseeable that someone who used them when they were broken would injure themselves. So he was suing for his medical costs. I mean, potentially if the injury was bad enough that it got him out of service, he should probably be thanking the district council, but because of course World War II was literally months away. The council, though, relied on an exclusion of liability clause contained within or on the ticket, just like the ticket case we just looked at, Parker. So the question was, did that exclusion clause form part of the contract? And the trial judge said yes. He said that the plaintiff had sufficient notice of the term, or should have had notice of the term, that a reasonable person would have known that there were terms on the ticket, and therefore, applying Parker, he was bound to those terms, including that exclusion of liability for negligence. He appealed, and his appeal was successful. The Court of Appeal held that in this instance, the ticket would not lead a reasonable person to believe, or the circumstances were such that a reasonable person would not believe that there were terms printed on the ticket that they got. Why? Well, you look at the facts. And the key thing the court says, or one of the key things is that there isn't a rule of law that can tell you in all ticket cases the terms apply, or in all ticket cases the terms don't apply. The question in all cases is one that's heavily dependent on the facts and what the facts would lead a reasonable person in the shoes of the recipient of the ticket to believe that the ticket did, or whether there were terms on the ticket and that bound him. And on those facts, the Court of Appeal said, this case is actually quite different from Parker in a number of ways. Firstly, you weren't leaving an item with the person giving you the ticket. Instead, you were taking an item for hire, the item being left on the ground next to a sign. And the sign had conditions on it. How long you could hire it for, 3 hours. The price upon which you could hire it for 3 hours, 2 pence. And there was no exclusion of liability on the sign itself. The sign did refer to a ticket or a receipt, but what did it say? It said, the public are respectfully requested to obtain tickets from the attendant and to keep them. If you are relying on terms and conditions on the ticket itself, you wouldn't say, we respectfully request you to take one. You would be a bit more forceful than that, the court said. You would say something like, tickets must be obtained, please refer to them for further terms and conditions, or something like that. What the sign suggested is that these tickets were to be obtained merely as receipts or vouchers to show that I have taken a chair and I've paid for it for the time specified. And so therefore, because a reasonable person would not think that these receipts or these tickets were to be taken for any purpose other than to be a receipt, any terms on this ticket did not modify the contract entered into. And in fact, the court says, when the beach was busy and there were a number of chairs being hired at any time, you could take the chair and for a large, if not all of that time you've hired it for, the attendant doesn't get to you. And therefore you don't have a receipt with these terms on it until halfway through your sitting time, or in fact, perhaps even you sit in the chair for 3 hours and at the end you have to go find the attendant to pay him or her. And you can't say there that if the process is such that you can start hiring the chair without getting a ticket, you can't then say that the ticket is necessary as setting out the terms of the contract. Because it just comes too late, might not come at all, and it's not clear to a reasonable person in these circumstances that the ticket affects what they're entering into. It was not a contractual document at all. It came too late. Once you take a seat, you are agreeing to the terms contained on the sign, which is very prominent and visible, but not to anything else. The ticket would be perceived to be only a voucher and a receipt. It's reasonable to perceive it as a voucher or a receipt, and therefore, contractually, it has no force. Or in the words of Lord Justice Goddard, in these circumstances you can't say a reasonable person would think that the ticket is a contractual document at all. And that's the question you're asking. Would a reasonable person think, in these circumstances, that this document was contractual? Yes?
Couldn't you rely on the reasoning, the same reasoning for Parker, in that he's already paid the money, the 2 pence, to leave his bag with the railway company
Yeah.
before he gets the receipt?
Right, yes.
That ticket.
Yeah.
And so therefore you shouldn't say, oh well, you've already paid the money, but then rely on the terms and conditions we've given you after this transaction's already completed.
Yeah, that would be an argument that you could rely on Parker. So remember, in Parker, the majority didn't decide whether or not it was a contractual document. They just sent it back to trial to be retried. And the question was, would a reasonable person believe that this ticket had terms on it? So the question would be, yeah, but you get the ticket after you've paid, you already entered into the contract, there's no ability to go back on it. Okay. Well, firstly, do you pay on handing over the baggage would be clearly important, or do you pay at the end? Secondly, I think you could fudge it a little bit and say that the ticket was given at the same time by a person who's standing right there. You have the opportunity to remonstrate or argue with that person at that time. And it's entirely practical and possible that you could say, hey, I didn't realise that this term was there. I'm not leaving my bag with you anymore. Give me back my 2 pence. And then that would be fine. Okay? As long as the railway company did that. If the railway company was like, no, we're not getting back your 2 pence, then I think you've got a very strong argument to say, I'm not bound. If I can't actually disagree and get out of the terms, then how can they bind me? So that would be a question. The difference here is that there's no one there at the start to take your money. If there was a booth with the person in the attendant, like a little booth with the chairs beside it, I think that would have been a different story. Yeah, and it would be much closer to Parker in that case. But you're pointing out the very good facts that this is entirely fact specific. And when you pay for it is going to be highly relevant for whether or not there is a contractual document. And we'll see in the next case, Thornton and Shoe Lane parking, the fact that you can't object to the terms and conditions is a very strong reason why it was not binding on the plaintiff. Any other questions? That's a very good one. Does it make sense why this was not binding on Mr. Chapelton? Good? Okay, great. Let's then look at another case where the terms didn't bind the plaintiff in Thornton and Shoe Lane parking. And there you had a situation where you got the ticket at the same when you entered into the building. But similarly to Chapelton and Barry, you couldn't actually complain at the time or get out of it at the time. We'll talk about why. So the plaintiff had never used this particular car park building before. As he drove up to the gate of this car park building, there was a sign which said how much it was going to cost, 0 to 30 minutes, 5 shillings, etc., etc. I'm not sure what the prices were. But there was also big letters saying, all cars parked at owner's risk. What does it mean, all cars parked at owner's risk? You go into a car park building, it says all cars parked at owner's risk. What does that mean? Yeah?
If you park here and something happens to your car, it's a you problem.
Yes, it's a you problem. More importantly, it's an insurance problem. You need to get insurance for your car, and you can't rely on the car park building to make good any damage on your car. Yeah, perfect. So he goes up to the gate, and it's an automatic ticket. He drives up, it's got a red light, he gets a ticket from the little machine, turns green and he goes in. He paid inside, so there's a real person there, he paid inside. And it was one of those car park buildings where it's, they took it away on I think like a lift. And then he picked up the car, and as he was picked up, he was badly injured. And the trial judge held that he was badly injured half through his own fault and half through the fault of the car park driver attendant who was driving the car back. And so he was awarded half of his losses. He was quite badly injured, which was about £3,000, or £4,000 almost. So he was suing the parking company for negligence, and the parking company relied upon a term that they argued was incorporated into the contract, a term that was contained on the ticket he got from the machine as he drove in, which they said excluded them from liability for their negligence. So remember, we're not talking about damage to his car. We're only talking about damage to him. So they can't rely on the sign outside, because the sign outside doesn't say, you enter at your own risk sort of thing. You enter. It says your cars enter at your own risk, but not you. So they have to rely on something else, and they're trying to rely on this exclusion clause, which excluded them from any liability, effectively, on the ticket itself. Except it didn't actually contain it on the ticket itself, because, of course, the ticket's too small. The ticket says, look, inside the building, there are terms and conditions on signs contained within the building. And those terms included an exclusion of liability for personal injury. So the question was not whether the terms on the ticket were part of the contract, but whether the terms inside the building were part of the contract when they were referred to on a ticket that you got when you went up to the gate. So Master of Rolls, Lord Denning, just as an aside, what does it mean to be Master of the Rolls? Does anyone know? Means that they are the lead judge in the Court of Appeal in the UK, the President of the Court of Appeal, the Master of the Rolls. They can contain the rolls which all the judgments are written on. Sometimes they talk about my learned friend sitting on the wool sack, because they used to sit on sacks of wool as well. The more you know. Okay, Master of the Rolls, President of the Court of Appeal, Lord Denning, says that, look, these ticket cases are based upon a theory that if you take the ticket and you read the terms, you are able to kick up a fuss and refuse them. And he says, look, maybe that's a bit of a fiction because no one will ever do that. But that's the theory. In this case, there is no option to refuse the terms. When do you get notice of the terms? When you go up to the little machine and it prints out a little ticket for you and you take them. Take the ticket, that is. Well, in that situation, you are unable to refuse. What does Lord Denning says? Because it's something relatively funny, except I can't find it. Here we go. None of these cases, he says, has any application to a ticket which is issued by an automatic machine. The customer pays his money and gets a ticket. He cannot refuse it. He cannot get his money back. He may protest to the machine, even swear at it, but it will remain unmoved. He is committed beyond recall. The point is that once you've gone up to the machine and got your ticket, you have entered into a contract with the parking building. And you cannot go backwards. And so once you've entered into a contract, one side cannot unilaterally impose terms on you after you've already entered into the contract, which is effectively what they're trying to do here. Just like in Chapelton, these terms came too late to bind the driver. That the contract was concluded when he took the ticket and paid his money. So that's why, well, one of the reasons anyway, why car parking buildings have a grace period at the start. 0 to 10 minutes free. The idea is you can go inside, take your ticket, read, please refer to terms and conditions inside. Go and read the terms and conditions, and if you don't like them, you can leave. But in this case, he couldn't leave because they didn't have that grace period. He was bound to the terms when he took the ticket. So the only terms that bound him were those that came before he entered the building or drove up to the machine at the entrance to the building. What terms were imposed on him then? Only those terms that were contained on the sign outside the building, which were any damage to the car, we're not liable for, the risk is on you. They didn't say anything about damage to persons. Liability to personal injury was not excluded. So the court says, look, this is just different to Parker. It came too late. It can't bind him. But in Obiter, the court also said, well, assuming that it didn't come too late, did the car park company give reasonably sufficient notice of the terms such that a reasonable person would be held to be bound to them? And the term itself was contained on a big board with a number of conditions with relatively small writing, and it was about halfway down where it said, we're not liable for personal injury. And the court says, that's maybe not good enough. That the question about whether sufficient notice has been given, now this is all Obiter, but the question about whether reasonable notice has been given will also depend on the term in question. That the more unreasonable a term is, or the more destructive of the rights of the party you're trying to enforce it against, the more explicit attention must be drawn to it. That it won't be good enough to bury it in a sign of terms and conditions. You're going to have to bold it in some way or draw particular attention to it by saying, here's your ticket, please refer to our terms and conditions. In particular, please read term 4, you're going to love it. That we're drawing it to your attention that actually you should read and be aware of and agree to this term. And so, even if it hadn't come too late, I think the Court of Appeal would have said this term didn't bind the parties because reasonably sufficient notice was not given to it. Which is different to whether if he'd signed a document that had exclusion of liability clause buried halfway through it, there's no question about notice. You are bound to it even if it's buried in fine print in the middle of the document, as it was in Lestrange and Grakop. It's different, though, when you're trying to rely on a written term that you're providing and the other party doesn't sign it. You're trying to show that they knew about it or they should have known about it. Well, in those cases, the court says the onerousness of the term is relevant to whether enough notice has been given. Okay. But the main reason for this decision is simply that the terms came too late to bind the parties. Hey, makes sense? Any questions about Parker? Yes.
What would happen if the term that was both sides was given on the tickets, but like say you've got, it's a super busy car park and you've got like 50 cars behind you that are saying go, go, go.
Yes, yes.
Do you just have, would that come into reasonably sufficient notice? Would they have to say like, you must sit there and read the thing before you go in?
Well, and also if you've got 50 cars behind you, what happens if you don't want to do it then? Can you turn around, reverse back? Yeah, I mean, that would be part of the question. Would it be reasonable? So you got the terms there. Is it reasonable then to be able to turn around and leave?
So you're on back up.
Yeah. So that's why if you've got a 10-minute grace period, you can go inside and leave without paying. So that would be better. But in this case, no, I think you wouldn't have that option in this case. Or didn't appear to, yeah, in this case. But again, all fact specific. Can you disagree and get out of the contract? If you can't, then those terms can't bind you because you've got no way of refusing them. And one party can't unilaterally impose obligations on the other party. Okay? So you need to be able to refuse them. You need to have sufficient notice of them and the ability, as I say, to read those, even if it's a theoretical ability to read them and then refuse to enter into the contract on those terms. Yeah. But even if it was on the ticket, according to the obiter as well, there would have to be some way in which that term, if it is an onerous term, such as even if we injure you deliberately, we're not liable, such that your notice has been drawn specifically to it. Okay. Good. Okay. The final case that we're going to look at about these ticket cases is Sperling and Bradshaw, which is a bailment case. What's a bailment contract? What's a bailment contract? Yes?
When you're holding on to something for someone.
Perfect.
Period of time.
Yeah, like a warehouse or your storage shed or something like that. You are giving goods to someone else, and the whole purpose of the agreement is that they are looking after your goods. And effectively, so that's right. You're hiring someone to look after your goods. So the defendant here had a whole number of casks of orange juice, apparently, which he placed with the plaintiff in his plaintiff's warehouse. The defendant then didn't pay for the warehousing arrangement, for the bailment, and the plaintiff sued for the overdue payments. And the defendant counterclaimed and said, okay, well, I didn't pay. But on the other hand, you were negligent in storing the orange juice, and because of your negligence, some of it was spoiled. The plaintiff said, we weren't negligent, but even if we were negligent, there is an exclusion clause in our contract. And this clause was contained on a receipt that was sent by the plaintiff to the defendant. The receipt on the front of it said that the goods that you store with us are not insured, which means or implies that therefore you should get insurance for your goods. And on the back, in small print, was an extremely broad exclusion of liability. So on the front it said, all goods are handled by us in accordance with the conditions as over and warehoused at owner's risk and not insured unless specially instructed. So that was on the front of the document. And on the back it said, we won't be in any circumstances when acting either as warehousemen, wharfingers, contractors, stevedores, carriers by land or agents, or any other capacity, be liable for any loss, damage or detention, howsoever, whensoever, or wheresoever occasioned, in respect of any goods entrusted to or carried or handled by us in the course of our business, even when such loss, damage or detention may have been occasioned by the negligence, wrongful act or default of ourselves or our servants or agents or others for whose act we would otherwise be responsible. That is an extremely broad exclusion of liability clause. Effectively, that's saying we can go into the warehouse and deliberately drink all the orange juice and we won't be liable for doing that. So the question is, did the contract or did the small print exclude them from negligence? Was there an exclusion in the contract itself? And the court starts off and says, well, look, let's have a look at this exclusion clause. That's a very broad exclusion clause. And in fact, to be taken literally, it would be extremely wide. Effectively, you would be paying the warehouseman to take your goods for as long as they see fit, and at any time they can deliberately destroy your goods or sell them to someone else, and you won't be able to sue them. If that's the case, then the amount of notice required would be very high indeed. You would probably need to show that the party whom you're trying to enforce this clause against had actual knowledge of the clause. He talks about, this is Justice Denning, I think, at the time. Oh no, Lord Justice Denning. Talks about you would need sometimes to have a red hand pointing to red coloured terms to really draw it to their attention. I agree that the more unreasonable a clause is, he says at 125, the greater the notice must be given of it. Some clauses which I've seen would need to be printed in red ink on the face of the document with a red hand pointing to it before the notice could be held to be sufficient. But he says, look, in this case, the clause should not be read that widely. And instead should be read as only applying when the warehouseman is doing their jobs of storing the goods with due care. Essentially, he says, and this all leads into the photo production series of cases around the effective exclusion clauses. But effectively, he's saying, if this clause was to apply, this would be a wholly one-sided contract where you're paying for nothing, really, because the other party can breach and destroy your goods at any time and you wouldn't have any recourse to them. Well, that's the very antithesis, or it's a fundamental breach of the warehousing arrangement. Why do you hire a warehouse? So your goods are securely stored and looked after. But that's not how we're going to read the exclusion clause. We're going to read it quite narrowly. But if it was exceptionally wise and unreasonable, then a lot would need to be done to draw it to his attention. And I think the reasoning for this is that, remember in Parker, which you should do because we literally just did it. In Parker, the court said, one of the ways you can show that the term is incorporated into the contract is if there's a course of dealing or business practice that there are terms and conditions contained within these tickets. So I think what they're getting at in Sperling is that it's accepted in the course of business practice that there will be terms and conditions, but that those terms and conditions are within the normal course of dealing and they're not exceptionally onerous or wide or unreasonable. That it is reasonable, the reasonable person would think there's terms and conditions in this types of case, but the terms and conditions themselves are not unreasonable. They're the normal, everyday sorts of terms and conditions. That's why we all sign the terms and conditions or click the terms and conditions online, because we all assume that the terms are reasonable or not completely unreasonable. But the more they're unreasonable, the more that must be done to draw them to our attention, to say this is not just an ordinary set of terms that you would expect in this kind of business. They are unreasonable terms. And I think that's why Lord Denning in this case says you need more attention drawn to an unreasonable term. And so it's not enough to know that there are general terms and conditions, but that there's the specific term and condition if it's unreasonable. But that's obiter, because Lord Denning says actually this clause was not that exceptional. And in fact, it only applied where the warehousemen were doing their job and trying to take care of the goods. And that fits in with the clause on the front of the invoice, which made it clear that any goods should be stored at the owner's risk. And therefore the conditions on the back, although they seem very wide, actually added little to that. So just like in Thornton, where there was a sign saying cars are stored at the owner's risk, here there was on the face of the invoice a clause saying that goods were stored at the owner's risk, and that wasn't amended by this wide exclusion clause. However, there was also the argument that even if that's true, the invoice was received after the contract was entered into. And therefore, the invoice cannot affect the contract because the terms contained within it were received after the contract was entered into. They were too late, just like in Chapelton and Barry, just like in Thornton. They were too late. Well, the court said that's true if this was a one-off contract. But however, on the facts, the defendant had stored many goods with this plaintiff. I don't know if it was orange juice, maybe other types of soft drink. And therefore, because he had stored many goods many times with this defendant, he had received this invoice, the same invoice, on many occasions. And therefore, he knew, or he should have known, that when he contracts with this warehouseman, these are the terms upon which he is contracting. And so what's known as the previous course of dealing gave him notice, or should have given him notice, of these terms. So the fact that they were late in this case didn't matter, because he already knew from prior instances what the terms were. So in fact, if he'd never received the terms this time, he would still be bound to them because he should have known what they were, because he had a previous course of dealing. Remember, in Thornton, the car parking case we just looked at, there was no previous course of dealing. The plaintiff had never been to that car park building before. This was the first time. Here there was a previous course of dealing, and therefore the notice of those terms was sufficient from this previous history, and therefore those terms were incorporated in. The question we're going to be left with, which we will answer on Wednesday, is what counts as a previous course of dealing? How many times do you need to deal to have a course of dealing? And we will answer that on Wednesday when we look at the Hollier and Rambler case. So we'll do Hollier on Wednesday, and we will start looking at when terms are implied into a contract as well. Have a good start to the week, everyone. I'll see you on Wednesday.